Hello, YouTube. I'm Vince White. I'm an employment attorney. On this channel, we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. My video today is going to be about 35 minutes late. It is 9:58 a.m. and my upload time is generally 9:30 a.m. I don't usually upload at 9:30 a.m. I usually upload a week or two of videos in advance. But we're playing it day by day right now. Things have been wild last week. People are just starting to come back, excuse me, from vacation, so we're starting to get a little caught up here. But we ran through all of our videos that were in the pipe, so we're getting caught up. I must remember to tell you, like, subscribe, comment down below. It helps me to help more people just like you. We have a question here from YouTube user Tevin. I'm not going to read the entire name because I fear it could be a full and proper name. Tevin asked us, "Good afternoon, counselor." Afternoon. Well, it's morning here, but the sentiment stands. "I've been following your streams here closely lately, and I thank you for all your insight you've given me, especially with your past few streams. I'm really glad. I hope they were helpful. If they were, like, subscribe, comment down below. I have a mediation coming up in September with my employer, or should I say my ex-employer, and the EEOC is involved." Good, good. "I do not know what to expect. Could you give me some insight?" Okay. So we have a video on the channel entitled, I think, something like "What to Expect from a Bad Mediator." Now, I had a mediation recently with a tremendously good EEOC mediator. There are very, very good EEOC employees. There are very, very good EEOC mediators. Most of the mediators for the EEOC are not any of those things. They're not especially good. I want to be clear that I certainly had mediations with EEOC mediators that were fantastic, including recently. However, often EEOC mediators are a little less trained and kind of unenthused, uncaring. It's a whole vibe. Now, the video exists for what you should expect from a bad mediator, but the video does not exist as to what you should expect from general mediation with a run-of-the-mill mediator. I'll be honest, the run-of-the-mill mediators are probably bad mediators, but we're going to say a mediator of average quality, like a generally competent mediator. Here's what you should probably expect. First things first, watch the playlist we have on preparing for mediation. That, I think, is going to help you to go into mediation fully ready to get done what you want to get done. And that, I think, has value. The preparation is everything. Knowing what you want, knowing your risk tolerance, knowing the strengths and weaknesses of your case. These things all matter a great deal to you. And I recommend going through that mediation preparation playlist. I think it's great. Now, the day of your mediation, if you have a mediocre or better mediator, there's going to be a brief statement from the mediator. Usually it's going to be on Zoom. Sometimes it'll be in person, but usually these days it's on Zoom in terms of what I'm seeing. And what they do is kind of have like breakout rooms. So I'll give you an example. We joined a mediation recently, and the mediator had everyone automatically zapped into different rooms and then brought everyone together, all the parties, defense counsel, my clients, myself, everybody into one Zoom session together. Gave a spiel on what to expect, gave a spiel on impartiality, the confidential nature of the process, how it's not, there's no decision being made. You don't need to litigate your case. The mediator can't force you to settle your case, right? And essentially, like there's a book that underpins a lot of the mediation thinking in the United States called Getting to Yes. And a lot of the sentiments were tied to that book. Like a lot of the opening statement expressed the concepts of like we're here to hear you, and this is an informal process, and you can say the things you want to say, and if you want to be heard, you can be heard, but also like you should think about the things you want, and litigation is hard and difficult and high risk and painful, and mediation is none of those things, right? That's the spiel essentially. And then mediator gave some time if any of the parties wanted to deliver statements, and then broke everyone up into separate rooms, separate Zoom channels, I think would be the phrase, and started bouncing back and forth. Now, prior to the mediation, the mediator had taken set demands, right? So each party came in at a certain dollar demand or a certain dollar offered. That's important, right? So everyone's at least serious to some extent about getting this case settled. Mediator bounces back and forth. Mediator goes to the plaintiff first and says, hey, you made the first demand. The defendants responded with a number, a dollar figure. Do you have a response for that? And, there's 40, 50 minutes of going back and forth about whether or not there should be a counteroffer, what the client wants to do, this and that. At any point, you as the client can ask to speak to your attorney privately. The mediator is also one who will keep things confidential if you ask the mediator to keep things confidential. And this mediator that we were working with did amazing at that. I will tell you that generally speaking, mediators are a little lackluster at their, we'll call it confidentiality control, right? I'm very careful about what a mediator gets to hear my client say because mediators tend to sink ships with their loose lips, right? They're very, we got to talk about things, give them flow, Evan, let's do it, let's talk, let's make something happen here. And that kind of free thinking style seems to go with information disclosures of the inadvertent variety, right? So you don't want to say something to the mediator that's going to sink your case. Or if you do, you want to highlight it to the mediator and just make it clear, hey, I'm saying this to you because it's important that I say it to you, but you need to keep this confidential. Really highlight the confidential nature, because if you don't, it's a very good chance the other side's going to learn about it. So just be aware of that, right? Be aware of the specific mediator you're dealing with, how dedicated they are to confidentiality as they talk one-on-one with parties, and underscore things to avoid an inadvertent casual slip. Generally speaking, what would happen next is the plaintiff would make some kind of counteroffer, right? So we'll just go with simple math. Let's say the plaintiff came in at $100,000, just for ease of math, just picking a round number here, and the defendant came in at $20,000. So then the mediator goes to the plaintiff. Plaintiff doesn't want to come down. There's a lot of conversation, talk. The plaintiff comes down eventually. She's like, all right, fine, I'll go to $90,000. It'd be very common for the mediator to go to the defendant and the defendant to just automatically hop from 20 to 30. Now, it all depends. It depends on where they're trying to end up and the strengths and weaknesses of the case and a lot of things, right? Now, that process continues until it doesn't, right? There's a lot of attorneys, right? If the plaintiff drops to 90 and the defendant goes up to 30, there's a lot of attorneys on both sides of the aisle, defense and plaintiff side, will just be like, let's split the difference. Probably not ideal. I mean, I get why they're doing that. They can be done with the mediation in an hour. But that's not, I think there's some work to be done in those trenches. And I'm going to describe a concept that's not going to resonate with any of the plaintiffs who watch this channel. The negotiation, there's a certain amount of traction on each give and take, right? So if the plaintiff's I'll go to 90, and the defendant goes to 30, right? And in our example, we started at 120, plaintiff goes down to 90, defendant comes up to 30. I would say, hey, let's apply a little extra traction on this next counter offer, next counter demand, right? And what I mean by that is the plaintiff might say, well, I don't want to go right away to 80. And I would say, yeah, definitely don't go right away to 80. Let's talk about an $8,000 or a $6,000 drop, if that's something you want, right? If you're aiming to get this settled and you want to keep making this deal and it still makes sense for you, be open to making moves, but don't make another $10,000 move, right? You want to use up, you have more traction than you think on these little moves. And if you go too big, if you're I'm only coming down 2, Well, it's like gunning your tires on snow and ice. Like they're just going to spin, right? But if you kind of keep in your mind, if you're on snow and ice, and I think my southern viewers are maybe not going to really gain a lot from this analogy, but if you gun your tires in snow and ice, your tires just spin. But if you gently gas your tires on snow and ice, they catch because you have some traction there. Your tires find some traction and you get a better result. So to here, am I saying don't just gun it. Don't just be like, well, we're only moving $2,000. Defendant moved from 20 grand to 30 grand, so we're only moving 2 grand from 90 grand to 88. You gunned it. Your tires are going to spin. The process is going to break down a little bit, and ultimately, if you do have a settlement, you're probably going to get less. Now, the other approach would be like, yeah, maybe we'll look at moving $8,000 or $6,000 down, and that's a choice for the client to make, the choice for the plaintiff to make, not the attorney. But that the attorney can recommend that, and the attorney can recommend, hey, if we use up all the traction that we have on every one of these back and forths, we're ultimately going to end up much higher than 60,000, right? Because they're going to have to be making these moves, and they can try to match you. But you got to kind of take up the slack here, right? Like, and this is, I'm doing a very poor job of describing this concept here, but you want to use up all the traction, all the juice you have in every back and forth, just constantly be getting better, right? You don't want, listen, you could just start at 100 and they can start at 20 and you can just say, let's split the difference. We're done. And that's fine if that makes you happy as the plaintiff. But you could probably do better in a lot of cases, depending on the facts and the circumstances dealing with that case. So, Tevin, eventually you're going to arrive at a number that works for people, or you're not, right? If you're not going to arrive at a settlement, if you can't have a meeting of the minds, like let's say the defendant gets stuck at 40 grand and the plaintiff's like, well, I'm not going down any further. That's just a breakdown of communication. That's what that is. I mean, you're not going to settle that case, and the mediator's eventually going to get frustrated and say, all right, everybody, I'm calling the mediation, everybody go home, right? Fair enough. That we don't have to settle. That's what litigation is for. The other way you can go is you eventually do have a meeting of the minds. You reach a dollar figure that gets the case done for everybody involved. Everybody's unhappy. That's always the sign of a good mediation. Everybody leaves unhappy. Not the attorneys. The attorneys are always generally going to be fine with the process, but the parties, the employer, the plaintiff, everybody leaves frustrated and angry. That generally means a fair deal was struck. Somebody's definitely going to get riled that I said it was a fair deal, because obviously I think people should get more for their claims than what they tend to receive. My little friend, the cat, is here. Yes. Thank you for visiting during my video. I don't know if you can hear her or not. She's just like at my feet, like telling me about her life. Yeah, if you do end up with a settlement, if you end up with a deal, the mediator will knock out a term sheet. It'll be executed by both parties. It'll be somewhat enforceable. Like, be aware that like reaching a deal verbally or on a term sheet, it's not as binding as executing a settlement agreement, but it is absolutely something that could be enforced, like potentially. Employers will try to enforce these. Judges will often enforce them. So just be aware that like what you're entering into at mediation could be binding. I know people are like, oh, mediation is non-binding. Yeah, but once you make a deal, you're bound. You're bound by the choice you made to make that deal, at least to an extent. And if you enter the settlement agreement, to a much greater extent, right? Like, so you get the term sheet, everybody executes it, and they might DocuSign it if you're remote, and then they'll take some time, usually a week or two, to draft a full and extensive settlement agreement, and the parties will execute that, and then usually you're looking at about 28 days for payment. Yes. Thank you. Tell them everything. So, Tevin, that's what to expect at a mediation with a generally okay to good mediator. I hope that helps. And I hope you get an amazing settlement next month in September of 2023. I am rooting for you, and I want good things. Take care. Like, subscribe, comment down below, And remember, everybody works, but not everybody wins. Be smart out there.